Hail to legal warriors. Believe it or not, sometimes in a very advanced strategy, it is a good idea to talk to the police. Only with an attorney, and only in certain circumstances. It's very advanced, and I want you to stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm has been defending people charged with crimes all throughout Washington State for more than 20 years and putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now, I can't wait to see the comments on this one. A lot of people, obviously for very good reasons, say never talk to the police. And that's standard law school stuff, standard defense attorney stuff. Never talk to the police. That's a very good way to look at things, and that is the primary rule that we should live by. We should not talk to the police if we're a suspect. And again, this channel is never legal advice. It's educational, but it's pretty obvious. We know that the police are going to try to fool us and trick us and do all types of things to get us to talk to them if we're a suspect to try to build a case against us. Now, for many, many, many years, that's how my law firm would live that way only. And sometime a few years back, we ran into cases, and since I was a prosecutor, I had a bit of for 7 years prior to doing defense work, a bit of a more holistic perspective of how things work. And I realized that if somebody is innocent of a crime, let's say a sex offense, something serious, and and they live by, the police come knocking and they say, hey, Mr. or Ms. Suspect, we want to talk to you to get your side of the story. And the innocent person who's a suspect, who's an accused, says something along the lines of, I don't talk to police. Well, that's fine, and that's probably a safe thing to do, but in that case, it may end up hurting the innocent person's case. And why is that? Well, number one, we have to realize how crimes that are serious, felony crimes, are charged in Washington State. They're not charged by a police officer. A police officer does an investigation and writes a report. They may make an arrest or they may not. But for felonies, an arrest does not necessarily lead to a charge, okay? So just trust me on this, that officers do not charge people with a formal complaint that starts an arraignment on a criminal information. They don't get to do that. That has to come from a prosecutor. So in the vast majority of serious felony cases, what happens is the officer hears from the people complaining, the alleged victim or victims, and then they gather some other evidence, talk to witnesses if there are any, then they want to go try to talk to the accused, the suspect. And let's assume in this hypothetical, the suspect, who this hypothetical is innocent, says nothing. They have some good information. They got text messages showing that they may be innocent. They've got all types of things that are inconsistent actions with someone who is a victim or someone of them being guilty, and they just say nothing. So what happens? Well, that police report then goes to the prosecutor's office, and they get around to looking at it. And when they look at the report, they say, victim says suspect did X, Y, and Z to victim. And suspect, who has the right to remain silent and the silence cannot be used against them, doesn't say anything else. So I'm the prosecutor. I just have one side of the story here. I have nothing pushing against it. Hell, I think I'm charging that one because looks like they did it to me. So it's not quite as simple as that, but that's the gist of why in some cases a suspect might want to get a well-prepared, practiced in some way, statement out to the police. So when that police officer sends in the report, the prosecutor can see both sides and realize there may be reasons to disbelieve the person making the allegations. There may be some very good reasons to disbelieve them that now get written into the report. And so now the prosecutor may think, oh, this one doesn't seem like I have enough to prove it, or heck, I might think the suspect is innocent. I'm going to decline that case and not charge it. So what a difference in a possible outcome, right? So, for example, in our office, how we would do things is if we were going to decide if someone were going to talk to the police, we would come into the very room where I'm filming this now. I moved my filming location to my conference room. I think the sound's a little worse. I hear it's a little echoey, so I may have to move it again. But we'd come into this very room, and I would sit here, maybe with another attorney, and talk to the client about what actually happened. And then I would talk to them sort of cold. I'll pretend to be a police officer and use my experience with police officers for years to, say, well, tell me what happened next, and what about this? And, well, isn't it true that X, Y, or Z? Whatever it is, to see how that client reacts. Does the client behave very clearly that they're innocent? Does they say no clearly that I didn't do this, or do they have the evidence that we could present? And people are nervous. Talking to the police can be pretty scary, and there's risks to talking to the police. But we make a determination with decades of experience of whether or not we think that client will help themselves or hurt themselves, and what the level of risk is to talking to a police officer versus not talking. And in those cases where we've had a client talk, we've yet to have anyone ever get charged with a crime. And so that is means that we're careful, but also that you can help yourself if you're innocent of something in some circumstances. And there's plenty of pitfalls, though. So what are some pitfalls to think about? And again, I would never tell someone to do this on their own. The disadvantage from an attorney's point of view in that situation, again, these are educational, so you can see how attorneys think. And what you might want to think about is that if there's a physical crime scene, there's a physical place where something happened, sometimes we're giving up pieces of the prosecution that might help them. Yes, I've been in that room before where a supposed crime happened. And if they start to lock you down to details that you get wrong with the physical space, later it could look like you were lying and they could use that against you, right? So that's why you have to be really prepared. You can also get caught off guard and say something that is taken the wrong way. And even from the attorney's point of view, sometimes your client doesn't tell you everything. So if you're working with your attorney, make sure your attorney knows everything because people don't always want to tell everything to their attorney. But the reason why we want to think about doing this in the right case is because if we're innocent and we have some proof or some good evidence we're innocent, I want the prosecutor to see that before they charge the case, because they think about it totally differently between a charged case and a not charged case. It's a nightmare once it's charged, right? To get them to even look at any other evidence. That's what trial's for. Then we got to wait for the jury to decide, and the jury thinks you're guilty because you're a defendant. So it's so important, if we can, to try to head off the charge in some way. And it might be impossible, but sometimes it's not, right? Living proof in this office, sometimes it's not. So, it's an advanced strategy. It can be risky, but it can also lead to high rewards. And it would only ever be used with an innocent client, because attorneys are not allowed to support mistruths, right? That's ethical violations to do stuff like that. So basically, if you're innocent and you have an attorney, talk to your attorney about, hey, is it a good idea, or is it even possible to talk to the police, or is it a bad idea? And most attorneys would say, heck no, we never talk to police, because it's just easier on the attorney, right? It's less risky for the attorney to not expose their client to interrogation. So there's lots of great reasons not to do it. But you really can't hurt yourself if you're truly prepared, truly innocent, and know your stuff. You're not going to admit to things that you didn't do. And so that can be the difference between being charged and not charged, your life ruined or not ruined, your freedom or prison. So this is educational. I'm not giving you advice, but I want you to at least think about things differently. It's not always true that we don't talk to police. That's where we start. In the long run, we might talk to the police if all the situations are right. So I hope you found this useful. If so, please like and please subscribe. More people get to see it. And more importantly, if there's a criminal case in Washington State, feel free to reach out to my firm. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.